Welcome back, ladies and gentlemen. You're watching Startup Central with me, Sumita, Kareer, and our second story this evening. Well, amidst growing concerns over the global impact of AI on how people consume and process information, major digital publishers in India have now come together to take on OpenAI for copyright infringement. In fact, the Digital News Publishers Association, or DNPA, has joined a prominent Indian wire service lawsuit against OpenAI in the Delhi High Court. The DNPA claims OpenAI unlawfully trained its language models on vast amounts of copyrighted content without permission, and that negatively impacted the Indian news industry. Now, the association argues that this practice benefits OpenAI and its investors while undermining transparency in the press and threatening the sustainability of journalism. In response, OpenAI, in its submission, has reiterated that it uses only publicly available data and adheres to quote-unquote fair use of principles. The company has also pointed out its partnerships with several news organizations, including those in India. But the big question is, what does this really mean for AI models and OpenAI in particular? And who's in the wrong right now? Is this just training your AI models on information that's publicly available? And does it not really account to piracy? To discuss all of those and many more points of views, we are now joined by Jaspreet, Bindra, the co-founder of AI and Beyond. Thank you very much, Mr. Bindra, for joining us here on ET Now.
Thank you. Thanks for having me here.
Now, Mr. Bindra, OpenAI's justification of what they are doing in India is that AI has the potential to enhance the news experience. How is that tenable? Because that essentially means that the company is not paying for content; it's training its models on information that's publicly available. And doesn't that amount to piracy?
Well, it's a very good question, Sumita, but we don't have a black or white answer. If you go back, now, one way to think about it is exactly what you said, that look, this content was produced by the efforts and investment and money by someone else. And therefore, you can't just come and plagiarize it or take it away without respecting the copyright, etc. And I think this is going to be a big argument which is going to be heard in courts, not only in India, but this matter is in courts across the world. But on the other hand, if you think about it, all human knowledge and culture has been built on top of knowledge or culture, knowledge which already exists. When you think about science, there's no copy. Someone does a research, publishes a paper, it's their effort, they get the credit, but someone publishes a paper, and then someone else takes that technical paper and builds on top of it and creates an invention, for example. And so there's the other way to think about it. So we don't have a black and white answer. The matter is in courts, including the London High Court. Some of the AI companies have already started, not taking an extreme view and having arrangements with publishers across the world, some financial arrangements. And many times publishers are also holding out to get the best financial arrangement. But I think going forward, we will have a scenario where in most cases, publishers of original content and these AI companies will have some kind of acknowledgement as well as commercial agreement so that both parties do get their due.
Mr. Bindra, now that's precisely the argument that has been made by DNPA, which states that if you can have these kind of arrangements with companies globally like the Associated Press, then why can't you have these licensing agreements with others as well? And we'll come to that point in just a bit, because we've seen these kind of cases play out globally as well, with respect to the New York Times, the Denver Post, the Chicago Tribune, all of whom have alleged issues of copyright protection. So what sort of precedents have those cases set, and how will those cases and the outcome of those cases really impact the lawsuit that these Indian news media companies have filed?
Upfront, Sumita, I'm not a legal expert. Okay, so I don't know what are the precedents which are there, which would allow, and what are the arguments which have been put by X or Y. I come in more from the AI, more from the technology and the ethics and the philosophy side of the debate. But while there are many players like NYT, etc., whom you mentioned, who are still at a where NYT and others and are kind of at loggerheads with with OpenAI and others, and each of them is holding out for the best deal. There are many where the agreements have been signed. AFP, for example, the big news wire in France, Springer, and a whole host of other publishers in Germany, uh, some publishers in the UK, including and some in the US, have actually signed agreements with these big models, not only OpenAI, even Perplexity, even some of the others. And I think, therefore, there are enough precedents out there. Now, I don't know what are the specific terms of these, and I'm sure that the terms are bespoke to each and every publisher. But I think all of these do serve as precedents, as models, which some of the other publishers could take. I in fact, sometimes think publishers are also seeing this as
Okay.
a business model and holding out for the best deal.
Okay. Now, one of the contention that these digital news media publishers really have is that, these AI models can really unleash a huge specter of misinformation as well. So that really needs to be taken into consideration as well before, regulatory models can really be developed around how AI models can actually train on data that's publicly available. And Mr. Bindra, you have other AI models also available in the market. But speaking specifically about the concept of fair use that OpenAI has mentioned, how does it really apply to AI companies which are trained on data that's available on the internet? Is it really fair then?
Well, if you've put it out publicly, at least from a technology lens, it's fair. Now, whether it's fair from a fair use as defined by the legal lens, I'm not aware of it, and I'm sure fair use is defined in different legal regimes differently. So I don't think that there is that much of a leg that either of them have to stand on, frankly, from the fair use thing. I think the way people have to look at it is, they need to take a step back. They need to say that, look, this technology is inevitable. It's going to happen. And what is the best way? And a lot of the data is going to be hoovered up, is going to be sucked up, public as well as non-public, to make these models happen. That is not going to stop. So in this scenario, what is the best way that both parties can actually come and make
Absolutely.
the best situation out of it? I don't think we can look too much at the past precedents, etc. And I just wanted to touch on the misinformation part that you mentioned for a bit. I think, frankly,
Right.
the fount of misinformation are not the AI models. We are looking at the wrong place. The origin of
Right.
where the
Right.
misinformation is social media, and that's where we need to look at to first address before we come to AI models.
Absolutely, because we did see, Mr. Bindra, during election campaigning, there was a lot of misinformation, disinformation, misinformation being spread via deepfakes and various other methods as well, and which is when the government had to intervene and issue advisories to these companies. But one final question before we let you go: what's a long-term mechanism do you see? Because very many startups in India now are also creating similar models, and some of those are very, very specific to India.
Well, the long-term arrangement that I see is really where publishers and the AI companies come into some kind of commercial agreements. There would be some agreements which would be bespoke when they are large publishers or tailored, but there could be some multiple models based on the precedents that already have been set, which companies sign up for and therefore get rewarded for it. Uh, when you talk about deep fakes, etc., we sometimes forget that, even if we create a deep fake with an AI, it's useless unless it's put on social media. So it's the distribution which is the problem, not the creation. And the only long-term way, therefore, is to recognize reality, sit across the table, work out a commercial agreement, because frankly, the AI companies are willing to do commercial agreements. They're not saying we will not do a commercial agreement with anyone. And we've already done some of them. I think for publishers and media companies, that's a great opportunity to bring in more revenue to their businesses.
Right, but Mr. Bindra, OpenAI categorically states in its statement that its models are built using fair use and related principles, and these models are supported and widely accepted, have widely accepted legal precedents, which again brings me back to the same point that I was mentioning, that if they can have these licensing agreements with some companies globally, why can't they have these kind of agreements with other companies who are now alleging them of course, plagiarism and of course unfair practices? Well, on that note, we'd have to wrap this discussion. Thanks very much, Mr. Bindra, for coming and sharing your thoughts with us on this developing story. Well, ladies and gentlemen, it's time's up from us right here on Startup Central. Hope you liked the show as much as we did putting it together for you. From me and the entire team, goodbye and thanks very much for staying tuned.